over to the phone lines and get to speak to a constitutional lawyer to give us an understanding of what transpired yesterday. Lawyer Paul Kumi, he's a constitutional lawyer and he's joined us on the line. Counsel, good morning.
Good morning.
Thank you so much for joining us on the phone this morning. If you can kindly help us unpack in summary what Madam Chief Justice sought to do yesterday.
Well, in essence, she's saying that a lot of the things that are being meted out to her are unconstitutional.
Counsel, if you could kindly speak up a bit for us.
Can you hear me?
Yes, it's better now.
I'm saying that she submits that a lot of the things that are being done to her are not constitutional, or for that matter, they are illegal. And that is what she sought to bring to the attention of the Ghanaian populace.
Okay, so now let's get into the specifics again with your legal education. One of the key things that she raises is denial of legal representation during the initial hearings. Is this supposed to be the case?
Well, if she's saying that initially she was denied, well, it is her word. I'm not in a position to doubt what it is that she's saying. But if she were to be saying that she is currently being denied, then of course that would have been a bit worrying. But if she said that that was what started initially, the indications are that currently no such thing is being done. And to the extent that no such thing is being done, I don't see why that should be an issue in the course of a press conference.
So at this point, let's get clarity. She has legal representation during the hearings.
Yes, so probably there might have been some miscommunication, and hence her lawyers probably not being given the kind of recognition that they ought to have been given by way of representing her. But I do not think that she says that is the situation now. And so to the extent that things are now in even keel and there's no such non-recognition of her lawyers, I do not think, and I repeat, I do not think that should be an issue that should be raised.
From where I sit as a commoner, my basic understanding of the law is that with respect to a case like this, from the onset, she is entitled to legal representation. Any particular reason whatsoever why at any point in this process there was a denial of a legal representation in the first place?
That's what I said earlier on. I said that there might have been some miscommunication in respect of who should be her lawyer or who it is that is formally known to the committee as representing her, right? And so if there were those initial challenges, and which challenges have now been resolved, I believe all is well, which is well. So now that whatever he thought initially was not done are now being done, I believe that should be okay. Unless she is submitting that at those times that she was denied that legal representation, certain things were done and we should go against her, right? But if there is no such submission that during the time that her legal representations were denied, certain things were done which by her estimation will go against her, I think we should let the sleeping dogs lie.
Again, counsel, if you could help me understand this. On the very first day she was supposed to have reported for the start of the hearings, we understand that on the very first day she herself did not show up, but her counsel was there. If you can help us understand this, is this allowed?
First and foremost, I do not know how the lawyers introduce themselves. And of course, the lawyers will not just go there and say that we are the lawyers of this person, right? They possibly ought to have been elected to the extent that the Chief Justice was not going to be physically present on that day. then there also have been a letter written by the Chief Justice in which he is appointing these persons as her lawyers, in which case that will be accepted. But for somebody to just go and verbally say that the Chief Justice didn't come, but he has asked me to come and represent her at this hearing, I think that would be a bit of a challenge.
Okay, thank you for that explanation. Now let's look at the other points that she raises in her speech yesterday. She talks of lack of clarity on the specific charges against her. Yesterday, listening to her, this was my understanding of that you say that she has done so and so and so, but can I get to know the specific charges? Is she wrong or right asking for this?
How did she answer to the petition? You recall the president sent her copies of the third petition as brought to the presidency against her. She requested for copies which were furnished her, and she also provided the requisite answers, for them. So to that extent, I want to believe that she understood and knew the thrust of what had been brought against her. In any case, yesterday, while she was even talking, she was giving specific examples of what those persons who were making the petition, wanted to drive at, right? And so that is a clear case of what those persons were bringing against you. Those people were saying that you traveled and the process by which she undertook the said travel violated what it is that she is supposed to have done, within the judicial service privileges that she enjoys. And she went on to explain. So that should give the indication that she understands what it is that has been said against her. And that's the reason for which yesterday she even told us what her responses are. So when she says she doesn't understand what it is that has been brought against her, exactly what is she talking about? Other than that, when she made references to those two persons, Danofori and the other gentleman, those are specific cases. Do you understand? And that's the reason for which she arrested them. So she cannot turn around and say that I don't understand. And if you don't understand anything, then how do you answer?
Was that answer, that presentation she made at that particular point was a bit difficult for an ordinary person like me to understand, because in her statement yesterday, she herself is speaking to some specifics. So how is there lack of clarity there? It's a bit difficult for an ordinary person like myself to understand.
That's the point I just made. That if she doesn't understand, then what was it that she was answering to? Because if somebody to ask you a question and you don't understand, the most prudent thing to do is to say that I don't understand. Can you expatiate? But once you go ahead and you answer, the presumption is that you understand. There's clarity in the said question that was posed, and that's the reason for which you are providing the answers to the said question. So with the greatest of respect to her, unless I don't understand her, but I think that it cannot be the case that she doesn't understand the petition that has been brought against her.
She raises a point about invasive personal searches. In respect to this particular case, what could be so invasive about a search?
Well, when you are searching the person and it goes beyond the normal decent search, trying to be touching some areas and being unnecessarily pushy and checking the armpit and things like that. I hope you understand what I'm saying.
I do. I do very well.
But this is what she has said. I am not in a position. She thinks that to a certain extent that is invasive to her. It is possible that the officer who is doing or undertaking the search doesn't see it that way. So this one is how she personally sees a particular issue. And that cannot be the standard which all of us are expected to dwell on. So with this one, I'm unable to say whether what she's saying indeed amounts to intrusive or invasive sex. I'll give it to her. If it is not being done right, there should be the attempt. At least she is the fourth most important person in the country, and at least there should be a certain decorous way to deal with her.
She's a very powerful person. I'm trying to get a picture of that level of invasiveness. Even if you are an officer who is tasked to, if you like, search her for whatever reason, you would surely be very careful in dealing with the fourth most powerful person in the country.
So that's why I said that the one who is testing possibly does not see what he or she is doing to be invasive. Right, but we will give it to her. That is how she sees it, and so I believe some of these things could have been discussed with the committee members. That when I come here, the way searches are conducted on me, they are a little bit dehumanizing and degrading, and so please just tell them, let me know things that I can bring here and things that I cannot bring, so that we'll know what to do. For instance, when she's talking about a telephone, which he will want to enter the room with, I ask, why she before the committee? Can she receive a phone call, answer it, and after which he can continue? So what it means in essence is that he doesn't even need the phone inside of the hearing room. The second point again is this. Because this whole thing is expected to be in camera, let me put it this way, the idea of things being surreptitiously recorded, or things, or some of the hearing or proceedings being surreptitiously transmitted out of the venue, is huge. And so the idea is that we don't want you to come in with any phone with which you may either do any recording or by which you can just do any transmission of the hearing. And so to avoid that, don't bring any phone. She makes reference to the fact that the petitioners and other lawyers are allowed to come with their phones. I'm not in a position to confirm that or to deny that. So I will not comment on that. I will only comment on her own. And again, because she's been so insistent that this whole thing must be public, could there not be the tendency on her part to want to even record what it is that is going on, or to possibly even transmit? So I think that if she's not being allowed, to a very large extent, I think she's being protected from herself, so that at least you will not get involved in something that will end up being criminal or being unacceptable. I have even considered the press conference that she organized yesterday. She brought out lots of issues which are expected to be essential in the province of the in-camera hearing. Now, under the law, these in-camera hearings are not supposed to come out. Issues that have taken place at the in-camera hearing are not to be brought out. And so, to the extent that she is even flouting the constitutional provision and coming out to tell the whole Ghana what it is that is taking place at the hearing, she could be seen to have flouted the provisions of the Constitution or the way she is expected to behave as an officer before the committee. She's not behaved right, and that could amount to a stated misbehavior, and that could even go a long way to, as it were, even culminate in her being sanctioned for that particular behavior or this particular news conference that she organized yesterday.
In line with the point you just raised about whether this should be held in camera or otherwise, Article number 1468 says all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other experts of his choice. Any particular reason why she would want something different?
Well, she's created the impression that there has been earlier statements made by operatives of the NDC during their campaign, making clear indication that if the NDC want power, it should be removed. And so what is happening to her currently is an agenda of the NDC which is being pursued. That is the submission she is trying to. And so probably her thinking is that if this particular hearing should be done in public, it will give people the opportunity to really hear all that is happening, and then they can be better judges of themselves. But unfortunately, just as you made reference to Article 1468, it is clear that this thing is supposed to be done in camera. So I don't see how she can even contemplate making a suggestion that even though this is a constitutional provision, I want that constitutional provision to be jettisoned or to be discarded, and for me to be treated differently. Because the point is that if that attempt is made to hear her case in the open, somebody will go to the Supreme Court and tell the Supreme Court that the Constitution is being violated and that 1468 is clear. So why is it that a different thing is being done? So I'm a little bit surprised that she is so insistent on her desire to have this hearing done in public, when she knows very well that Article 1468 says that everything is to be done behind closed doors.
Counsel, one final question, because I know you have a lot to do this morning. She also has issues to do with the chairman. She raises a case involving one of the petitioners, and the fact that Justice Poman dissented on that particular issue. So she has an issue with Mr. Poman being made chairman of the committee. Can we decipher from what she said with respect to what the Constitution say? The Constitution is clear that one of the two justices of the Supreme Court who will be nominated, one will be made a chairman. What has the president done wrong there? And in the case involving why she has issues with Justice Poman being involved in that case as well, because she sat on a case involving one of the petitioners, can we also, ordinary people like us, also decide that because a justice sat on my case some time ago on an issue and I lost, now me too, I don't want this justice? Does it work that way?
No. Indeed, cases which go to the court, what you do is to just go and file your case. When you file your case, there is an allocation committee, and then a particular court will be chosen depending on the particular matter that you are suing on. And then that case will go to a particular court. So, for instance, if you are dealing with a land matter and you file at the registry of the land division, they will then decide which of the various land courts you should go to. We have not less than 13 land courts here at the High Court. So the judge will not go and say that I want this particular case, bring it to me. The allocation is made, and he just in his court, the case is brought to him or her, and he presides over it. Now at the Supreme Court, there is what is known as the empaneling. And the empaneling is done by the Chief Justice. And so in the case of Gabriel Poman, in a particular case that he happened to preside or happened to be a member of the panel, he didn't empanel himself. He was sitting somewhere as the Supreme Court judge. And then he was empaneled. Now, whatever it is, others were reasoning in a particular way. He decided to dissent. What is the beef about it? His understanding of the evidence and his application to the law is what led to he dissenting from the other. So that cannot be an issue which can be brought against him. That for the simple reason that one of the petitioners has had a case before him, it means that he's going to be positively biased towards the said Danofori. Not at all.
How do you foresee this case going?
Unfortunately, we have pushed it from the very legal stature to a political one. You will realize that even the MPP minority group in Parliament said that it was not going to even participate in the confirmation of the 7 Supreme Court justices, right? And if you listen to Afenyo King, he has been making a lot of, I don't want to use the word noise, it's offensive. He has been making a lot of submission, to the effect that it appears the justices of the Supreme Court are not doing anything as one of their own, and especially so in their head is even being wrongfully handled. I do not think that anybody can point to any aspect of the Constitution which has been flouted by the government of the day in respect of this investigation touching on the allegations made against the CJ. I would rather have prayed that we did away with all the politics of it, allowed the committee to proceed to hear the matter, look at the evidence as presented, look at the law that ought to be applied to it, and for them to make the appropriate recommendation to the president. But the way it is now, it has become very, very, very partisan, and I fear for the outcome.
Counsel, we appreciate the dedication this morning. Thank you for speaking to us.
The pleasure is mine.